Good evening, everyone, and welcome to Great Conversations. I'm Bart Schultz, your host for the Great Conversations series. And as usual, it's great to see so many familiar faces and so many new faces. We have a wonderful event tonight, and since we're starting a few minutes late, I want to get right to it. Needless to say, you have to do the obligatory advertising, but I'll make it short. Please be sure to pick up a copy of our catalog, The Complete Gargoyle. Find out about other great conversations in the works, courses coming up, lots of interesting things that the Graham School of Continuing Liberal and Professional Studies has put together on the educational front. Hope to see you all back here soon for more great conversations and other Graham School events. So I'll leave the advertising there, because we have a very distinguished guest and a very long resume to cover this evening, and I want to introduce him straight away. Professor Geoffrey R. Stone has been a member of the law faculty at the University of Chicago since 1973. From 1987 to 1993, Professor Stone served as dean of the law school at the university, and from 1993 to 2002, he served as provost of the University of Chicago. And as you all know, that's the position that really carries a lot of weight. You're pretty much running the academic side of the university. So our speaker knows the University of Chicago very well, but he knows many other institutions very well. And I want to give you some sense of just how wide-ranging and intellectually impressive this special guest is. He teaches primarily in the areas of constitutional law and evidence, and writes principally in the field of constitutional law. His most recent books are Speaking Out, Reflections on Law, Liberty, and Justice, Top Secret, When Our Government Keeps Us in the Dark, and War and Liberty, An American Dilemma. Professor Stone's Perilous Times, Free Speech in Wartime from the Sedition Act of 1798 to the War on Terrorism, received the Robert F. Kennedy Book Award for 2005, the Los Angeles Times Book Prize for 2004, the American Political Science Association's Kammerer Award for 2005, and Harvard University's 2005 Goldsmith Award for the best book in the field of public affairs. I warmly recommend that you take a look at Perilous Times, especially if you think that the Perilous Times are still ongoing. This is a pretty important work for coming to terms with the state of freedom in the United States. Professor Stone is also currently chief editor of a 15-volume series, Inalienable Rights, which is being published by the Oxford University Press. Published quite a few titles in that series already. Professor Stone is also working on a new book, Sexing the Constitution, which will explore the historical evolution in Western culture, the intersection of sex, religion, and law. And he has many other past works as well, but I won't go over them now. Among his many public activities, Professor Stone is chair of the board of directors of the American Constitution Society, a member of the National Advisory Council of the American Civil Liberties Union, a fellow of the American Academy of Arts and Sciences, a fellow of the American Philosophical Society, a member of the American Law Institute, and on and on. He has in the past served as chair of the board of the Chicago Children's Choir, a wonderful organization that we encourage you to check out the Chicago Children's Choir, important civil rights institution all on its own. A member of the executive committee of the Association of American Law Schools, a member of the board of advisors of the National Association of Public Interest Law, a member of the advisory board of the Legal Aid Society, a member of the board of directors of the Renaissance Society, board of directors of the Smart Museum, a member of the board of governors of Argonne National Laboratory. The list really does go on, and I wish I could do full justice to his many accomplishments. Suffice to say, he's an extraordinary scholar, a wonderful citizen and a wonderful citizen of the world on top of all that. In my experience, Professor Stone has always been a perfectly wonderful, admirable, down-to-earth individual, despite all these accomplishments, despite being, as many of you know, safe to say, an advisor to presidents, at least Democratic presidents, President Obama, someone who I think has more than your usual scholars take on the state of the Constitution and the state of freedom in this country and the world. So please do give him a very warm welcome this evening.
That was a rather extravagant introduction. I'm delighted to be here. I'm a fan of the grad school and of this program, so I'm really pleased to have the opportunity to speak with you this evening. So, when Bart asked me to speak about freedom, there's a lot of facets of that subject that one could ask. The one that interested me for a while now, and that I do want to focus on, is freedom and the role of the Supreme Court of the United States in our constitutional system. What is the function of the Supreme Court in defining and protecting freedom in the United States? And to get at that question, I want to talk a bit about I think the critical divide in the way we think about the role of the Supreme Court. That divide between what is known as judicial activism and judicial restraint. Some of you may know I've not been tribune that about the subject. This will be a little longer than that, so it's okay. So, what is judicial activism? People use that phrase. For one thing, it's in the eye of the beholder, but in general, what it means is when a court chooses to take a fairly muscular view of its power to define and apply the Constitution in the face of the argument of the elected branches of government, or the state or the federal level, they have acted constitutionally. The court does not refer to the judgments of those other branches of government, but makes an independent judgment itself about the meaning of the Constitution and its application to a particular challenge law, and will hold the government to a high burden of justification for holding that challenge law. Judicial restraint typically represents those situations in which the court takes a more passive view of its authority. It essentially says, well, if this law is reasonable, it seems to us to have a legitimate justification and rationally, reasonably further that justification, we'll give the benefit of the doubt to the elected branch of the government, and we won't require a compelling case to be made as to why this is constitutional. We'll defer to their judgment and uphold the law as long as there's a reasonable justification for what they've done. Now, in simple terms, most of the function of the Supreme Court is in putting particular controversies into one of those two categories. Now, in the real world, it's not so black and white. There are all sorts of degrees of activism and restraint, but in general, that's a simple, straightforward, and useful way of thinking about how the Supreme Court sorts cases and how it approaches the issue of constitutionality in any given case that is before it. Now, the first thing I want to do is to debunk the idea that has become prominent in public discourse in the United States that liberals are judicial activists and conservatives employ judicial restraint. If you took a poll of American citizens and asked them to match liberal activism, conservative restraint, the vast majority would assume liberals are activists, conservatives are passive. And that's the result of a political effort to convey that understanding that's gone on now for almost half a century. But in fact, it's not remotely that simple. There are circumstances in which conservative justices have been very active and attacked by their liberal opponents precisely for illegitimate activism. So, for example, the first real controversy over judicial activism and judicial restraint in American history occurred in the early years of the 20th century, when a very conservative set of justices on the U.S. Supreme Court held unconstitutional a broad range of progressive legislation enacted in the states, in cities, and in the federal government, designed to protect workers in terms of minimum wages and maximum hours, and to protect health and safety of workers. They held those laws unconstitutional on the claim that they violated the liberty of contract. Now, those decisions were activist by any reasonable standard in two respects. First of all, there is no liberty of contract explicitly in the Constitution. It was something that the justices inferred within or between the text of the Constitution. And second, in testing the constitutionality of those laws, the justices did not give any deference to the judgments of the elected branches that such legislations were necessary to serve legitimate government purposes. Instead, they placed a very high burden on the government to convince them that these laws were absolutely necessary to meet compelling governmental interests, and anything short of that was unconstitutional. So the first real iteration of systematic judicial activism in the United States was conservative judicial activism. And it was bitterly attacked by progressives, who took the position, not only in terms of this issue, but in general, that judicial activism is illegitimate, and that the proper role of judges is to be restrained. And individuals like Felix Frankfurter and Louis Brandeis in the 19-teens and 20s were strong progressives, and therefore strong advocates of the position that the Supreme Court was acting illegitimately in all those cases, and moreover, was acting illegitimately because judges should not behave that way. That interpreting the Constitution, judges should give deference to the elected branches of government. Those branches have an equal responsibility to apply and observe the Constitution to the judiciary. And although a court could legitimately hold a law unconstitutional if it served illegitimate ends or was really unreasonable, that was the scope of appropriate judicial intervention. So in the first major battle over this issue, it was the conservatives who were activists and the liberals who were, the progressives, who were in favor of judicial restraint. And as I said, not only in the particular context posed by those cases, but in general, their view of the role of judges is restraint. Okay, eventually, that era ended, and the new generation of justices looked back on those cases and generally found them to be wanting and illegitimate, and the vast majority of those decisions were overruled as unwarranted examples of judicial activism. The next major wave of judicial activism in the Supreme Court occurred during the era of the Warren Court. The Warren Court also was activist in the sense that it both gave a aggressive interpretation of the meaning of the Constitution, and in a significant set of cases did not give deference to the elected branches of government as to the constitutionality of a broad range of laws. Instead, the Warren Court said laws dealing with a range of subjects have to be tested independently by the judiciary with a rigorous requirement on the part of the government to justify these particular laws without any deference being given. And if they fail to meet that test, the laws are unconstitutional. So that was the second major era, and it was totally flipped, right? Then it was essentially liberals who were now being activists. Okay, in the modern era, it's also the case that we see now a return to conservative activism. So now we have justices who are clearly conservatives, appointed by Republican presidents, understood to be both ideologically and judicially conservative, who decide cases like Heller, which invalidated laws regulating guns, that is taking an aggressive approach to the Second Amendment and holding gun control laws unconstitutional, or Citizens United, taking an aggressive approach to campaign finance reform and holding those laws unconstitutional, or in affirmative action, taking a very aggressive approach to the Equal Protection Clause and invalidating laws that provided affirmative action programs, and the like. So now again we see conservative justices who are being activists, and for the most part now we see liberals who are criticizing them for doing that. So a major problem in thinking about the appropriate role of the Supreme Court is when should it be activist and when should it be restrained? Clearly, it can be employed by those who are politically either liberal or conservative. It just depends what axe they're trying to grind. Now, one approach to this problem would be to say, you know, if you let justices be activists, what's going to happen is they will simply invalidate laws that they themselves don't like, that they as individuals don't like. And that's not a legitimate approach to the judiciary. It's a power that no one intended to give judges, to be Platonic guardians who would sit up there and decide whether I would vote for that law or not. And if I wouldn't have voted for that law, I'm going to hold it unconstitutional. And the fear that that's what judges were doing, particularly after the Warren Court era, led conservatives at that time, particularly like Richard Nixon, to take the view that judicial activism was wrong. And Nixon took the view similar to that of Frankfurter and Brandeis 50 years earlier. The view he took was that judicial activism was inappropriate, period, and that the right approach is judicial restraint. And conservatives of that era jumped onto that bandwagon and essentially said that we can't trust judges with the power to be activists. They really should be limited to giving deference to the elected branches. They can hold laws unconstitutional when they're grossly, obviously unconstitutional, but otherwise they should stay their hands. And so when Nixon ran for president in '68, that was basically the attack he made on the court, on the Warren Court. It was that the Warren Court was making up the law to suit their own fancy, and that the only approach that makes any sense for judges is restraint. And that was the meaning of conservatism at that particular time in our history, in the same way that the meaning of liberalism 50 years earlier was also judicial restraint across the boards. And so when Richard Nixon nominated people like Warren Burger and Harry Blackmun and Lewis Powell and William Rehnquist to the Supreme Court, they were all understood to be proponents of judicial restraint. That is, what they were expected to do in their jurisprudence was to be passive, was to uphold laws that the Warren Court might have struck down, and that the earlier conservative court in the 1920s and 10s would have struck down, that they would be restrained. And indeed, for the most part, with some notable exceptions, those justices did in fact adhere to that kind of approach to their judicial responsibilities. They basically took the view that they should be relatively restrained and passive in their performance of their judicial duties. Now, one might say, okay, that solves the problem. The problem is we don't want judges being able to impose their own values and predilections on the entire nation in the guise of interpreting the Constitution. The best way to protect against that is simply to say judges really don't have much power. Now, conservatives, interestingly, at that time, a decade later, thinking in terms of principle, really were troubled by this. And they were troubled by this argument because they rightly understood that judicial restraint of that sort, in all circumstances, across the boards, abdicated a fundamental responsibility that courts were supposed to have in our constitutional system. When the Constitution was drafted, the framers were, of course, very troubled by the dangers as well as the advantages of democracy. They knew that factions could take control of government and use it in ways that would be not in the public interest, not in the interest of the nation as a whole, not in the interest of the public as a whole. Human beings being what they were, the framers were acutely aware of this danger. And so one of the things they did was separation of powers and different branches of the Congress and checks and balances and the like. And they tried to structure a government in which it would be very difficult for transitory majorities to actually become overly powerful in their ability to implement laws that suit their particular interests. But they were also worried about the fact that despite those checks and balances and separation of powers, there would still be instances in which there would be a problem. Now, this came to a head in the discussion over the Bill of Rights. So the original Constitution, as drafted and as put forth from the Constitutional Convention, did not include a Bill of Rights. It had no guarantee of freedom of speech, freedom of religion, freedom from reasonable searches and seizures, freedom from cruel and unusual punishment. It had none of those guarantees. And one of the reasons why the framers of the Constitution did not put a Bill of Rights in the Constitution was their view that it would basically serve no purpose. That is, their view was that it would be just hortatory. You'd be like giving a patriotic speech. But majorities would be able to do what they wanted anyway, even if these things were listed in the Constitution. And if the majority at any given point in time wanted to pass a law that violated somebody's notion of freedom of speech or somebody's notion of freedom of religion or somebody's notion of unreasonable searches and seizures, nothing would stop them from doing it. And so listing these things in the Constitution, they thought, would serve no effective purpose, but it would lead, unfortunately, to a kind of disillusionment with the government. Because people would say, what about these rights? And the majorities would just do what they wanted to do anyway. And so that was one of the reasons why they didn't include a Bill of Rights. They thought it would be pointless. Madison described them as parchment barriers. So after the Constitution was drafted, it was sent out to the public, and one of the people who got it was Thomas Jefferson, who wasn't at the Constitutional Convention, but it was off in Paris at the time as ambassador for the United States. And when Jefferson saw the Constitution, he was appalled. And he wrote back to Madison, who had sent it to him, and he said, this is pretty good, John, but what about a Bill of Rights? There's no Bill of Rights in here. We can't have a Constitution without a Bill of Rights. And Madison wrote back, and he basically explained that a Bill of Rights would be pointless because it would be a parchment barrier. You would just list these things, and then majorities would just do whatever they wanted anyway, and there was nobody to check that. There was another reason, by the way, which is a little off the subject, but it's interesting enough to mention, why they didn't believe a Bill of Rights was necessary, and it is relevant to the subject. And that's that in the history leading up to American independence, you needed the Bill of Rights against a monarch, right? That the people needed to be protected against the sovereign. And the Bill of Rights was meant to provide some check on what the monarch, who basically possessed otherwise all power, was able to do. But once the nation created a self-governing society, the argument was, well, who do you need a Bill of Rights against? There is no sovereign. There is no monarch. It's just us, right? So we don't need a Bill of Rights to protect us against us, because we're not a bad guy, right? We're just us. Okay, so Jefferson writes back to Madison. I'll come back to that point. Jefferson writes back to Madison and says, what about the courts? He says, and this was not a new idea. The courts had acted already in the colonies in this way in many of the states. But he writes back and he says, what about the courts? Independent tribunals of justice, judges with life tenure who have a responsibility and a training that is designed to insulate them from the political process, insulate them from the majority, can enforce the Bill of Rights against the states and against the federal government to prevent majorities from doing inappropriate things. And Madison was persuaded by that. And so when he introduced in the first Congress the Bill of Rights, he basically rehearsed this entire discussion and mentioned Jefferson's objection and then mentioned Jefferson's answer and endorsed it and said that courts are the answer to this puzzle about who will enforce the Constitution against majorities. It's judges. That's why they're there. That's why we give them life tenure. That's why they can't be removed except for good cause. It's to insulate them from political winds. Alexander Hamilton in the Federalist Papers made a strong argument in favor of judges having this responsibility. Okay, so the problem then, to come back to the present, or to come back to 30 years ago, is conservatives were troubled by the idea of judicial restraint across the boards, because they understood that was incompatible with the framers' understanding of what it is courts were supposed to do. If courts were going to be truly deferential, then they would really not fulfill what the framers meant for them to be able to do in terms of being a meaningful check on majoritarian government. And so the conservatives, people like Robert Bork and Antonin Scalia and Ed Meese, thought about, okay, is there a better way? Is there a way to both guard against judges running amok and doing whatever they feel like in the name of the Constitution, on the one hand, and abdicating all of the responsibility that the Constitution is meant to impose upon judges, on the other? And that's where originalism comes from. So the modern iteration of originalism was an effort by conservatives to come up with a methodology that would both restrain judges on the one hand, but empower them on the other. And the idea was that judges would stand in the shoes of the framers. That essentially they would invalidate only those things that the framers or the framing generation at the time they ratified any particular provision of the Constitution intended and expected to be unconstitutional, but not beyond that. So if they just put themselves in the shoes of the framers and invalidate the laws that the framers themselves meant to hold unconstitutional, then they'd be acting legitimately, but they'd be constrained because they couldn't start roaming around and deciding to make up concepts and ideas and doctrines that they think suit their fancy, but which aren't really sufficiently grounded in the Constitution. So conservatives then moved from judicial restraint across the boards to originalism as the argument for the appropriate way that judges should behave. And originalism, in fact, has a certain appeal. It actually does, at least in theory, meet these two objections. On the one hand, it constrains judges from just going around and deciding what they think the Constitution should mean, but on the other hand, it avoids judicial restraint by leaving them the authority to do what the framers themselves specifically intended them to do. Nonetheless, there are two fatal flaws in originalism, both of which have in fact proved to be pretty well definitive. The first of them is that in most cases that come before the Supreme Court, for example, if you look to the history to try to figure out what the history dictates, what you discover is that it doesn't. The problem is that originalism envisions a historical inquiry that, in fact, we can't do. We can't do it because the framers of these various provisions, Congress shall make no law abridging the freedom of speech or of the press. No state shall deny any person equal protection of the laws. No state shall deny any person life, liberty, or property without due process of law. They had no idea what these things meant. They were adopting open-ended, broad, aspirational principles. The framers of the First Amendment had never lived in a world of free speech as a legal concept. They didn't know what it meant. They had no understanding of what it meant, nor did they try to figure it out. There were no debates at the time the First Amendment was enacted about the concrete meaning of Congress shall make no law abridging the freedom of speech or of the press. They were smart enough to know it couldn't mean what it appeared to say. Right? Oliver Wendell Holmes used the hypothetical of the false cry of fire in a crowded theater to prove that it can't mean that the government can never abridge the freedom of speech. But once you open that, once you recognize that, then it's all open, right? There's nothing that's determined by this text. And the same thing is true with most of the other important provisions of the Constitution. The framers themselves not only did they not tell us what they thought, they didn't even talk about these questions in most instances. So when you look to the history, what you almost invariably discover is that either there's nothing at all, or if there is anything to look at, it's ambiguous. There are comments made by people on both sides. None of them think they're making any dispositive statements. None of them think they're controlling the future. And in fact, when historians look at these questions, they, almost without exception, come to the view that, well, 6 of one and a half dozen the other. There's nothing definitive about it. So then the question is, what do judges who are trying to be originalists in good faith, trying to be originalists, what do they do in this situation? They look at the history, they say, our job is to figure out what the framers meant by this provision. Right? Did they think the guarantee of freedom of speech protected sexual speech on the internet? Right? And they look at that, and of course they can't find any answer to that question. And so what they basically do is they say, well, okay, the framers were reasonable people. I'm a reasonable people. This is what I would have intended had I been a framer. Therefore, this is what the framers intended. And so what they wind up doing, almost, again, without exception, is to project their own understanding of what would be a good constitution, given their particular political, moral, religious values, and simply impose that into the Constitution in the guise of adopting the views of the framers. And one of the interesting ways to see the reality of this is that if you look at the decisions of justices who purport to be using originalism, generally conservatives, but occasionally in response, liberals as well, they always come out the way you would expect them to come out, knowing nothing about originalism. If you were to simply predict what you think they would do based upon their past voting patterns, their general outlook on their role as judges, their general views about law and society and politics, they always find the history to support those views. So nothing could impeach a methodology more quickly than you look at the results and you look at the methodology, and if everybody reaches the result they would have reached without the methodology, you got a pretty good bet the methodology is irrelevant. So that's one rather strong deficiency of originalism. The evidence isn't there to support it, and when it's ambiguous, what the judges wind up doing in any event is just sort of making it up as they go along and blaming it on the framers when the framers didn't have any of these views at all. The second problem with originalism, so let me stop a second and say, a stronger defense of originalism would be this. Okay, originalism is not really very helpful, in fact, in cases where the history is ambiguous, where we really don't know what they thought about a particular question. Then, okay, we have to do our best to decide it. All law is you got to do your best. And so originalism may not decide a lot of the cases. But originalism takes off the table a wide swath of possible interpretations of the Constitution because they could not possibly have been intended by the framers of the particular constitutional provision. And that much we can know without dispute, that the framers did not affirmatively intend the provision they were drafting at that moment to have certain consequences. So for example, the equal protection of the 14th Amendment, equal protection clause of the 14th Amendment, which says no state shall deny to any person the equal protection of the laws, was not affirmatively understood by that generation to prohibit laws discriminating against women or against gays. Nobody could argue that the framers affirmatively had in their minds the understanding that this text would invalidate laws discriminating against women or against gays. They clearly did not. And so proponents of originalism would say, okay, originalism may not help us in the hard case, but in a case like that, it's easy. Or abortion. Clearly, the framers of no provision of the Constitution affirmatively intended when they drafted and ratified that provision, eliminating the ability of the states to prohibit abortion. That's clearly correct, unimpeachably correct. And so the proponents of originalism would say, okay, there are lots of things originalism can't decide, but there are lots of things it can decide, and it takes those issues off the table completely. So that's at least a defense of originalism. Now the problem with that is it runs into the second difficulty. And the second difficulty is originalism as a theory is internally incoherent and self-contradictory. That is, what it purports to do is to interpret and apply particular provisions of the Constitution through the eyes of the people who drafted those provisions. And so they would say, we know the framers of the Equal Protection Clause did not affirmatively expect that clause to prohibit discrimination against women. The problem with that logic is that the framers of these open-ended provisions did not intend them to be interpreted that way. They did not intend them to be interpreted by future generations as limited to the very specific expectations that they themselves may have held at that time. For the original Bill of Rights, for example, the drafters were men of the Enlightenment. Right? They understood that knowledge grows over time. They understood full well that they were drafting broad, open-ended provisions that were meant as aspirational. They stated values that were important, but they had no idea what the freedom of speech or the freedom of the press was, or might become, or would be. And indeed, as we as a society learned and evolved, they fully would have expected that the content of those phrases would change with our understanding of society. And similarly with the Equal Protection Clause, the idea that equal protection of the laws should protect women as well as African Americans, although not in their mind, is easily fit within the concept of equal protection of the laws. They could have said, no state shall deny any African American the equal protection of the laws, but they didn't. They adopted an open-ended provision that was not limited to blacks, and they did so for a reason. They were adopting a principle. And the principle, they understood, could evolve over time. As our understanding of gender has changed and our understanding of the principle of equality has changed, it's easy for us to accept the notion that equal protection of the laws does protect women as well as African Americans, and today, maybe even gays. And that's exactly the kind of methodology the framers themselves would have expected and intended. So the problem with originalism on this second basis is that it imputes to the framers a narrow, crabbed intent. These provisions should be used only to invalidate those specific things that we now intend affirmatively to invalidate, which was not remotely their understanding or their intent. And so if you go back to their actual understanding or intent, originalism doesn't help you. You're still stuck largely with the problem of how do you decide when to be activist and when to be restrained. And so originalism, which has been subjected to this kind of a critique, has largely been discredited in its, at least in its kind of Bork-Scalia iteration. That still leaves us though with the problem, what do we do? Right? What is a court supposed to do? It can't be judicially activist for every law. That would make almost everything unconstitutional. It shouldn't be restrained for every law, because that would abdicate a fundamental responsibility of the judiciary. Originalism turns out, even if well-meaning, not to be a useful solution. So we're still left with the problem of what do we do? So my argument would be that the right approach to this situation is to ask, why do we need courts to have the power to invalidate unconstitutional laws? Why do we put that institution in the Constitution in the first place? What's the reason for having it? What are you trying to prevent by giving courts this power? And it turns out the framers were very explicit about this. As I said earlier, they were very uneasy about majorities. And they were distrustful of majorities. And although they thought it was the best of all possible governments, they knew it also carried huge dangers. And a central one of those dangers was their fear of majorities. Their fear that majorities would act in ways that were irresponsible, that were intolerant, that were bigoted, that were prejudicial, that were short-sighted, and they needed a check on that. And so in presenting the Bill of Rights to into the Constitution and the later amendments after the Civil War, the framers were essentially saying that these provisions, guaranteeing freedom of speech, guaranteeing freedom of religion, guaranteeing freedom from reasonable searches and seizures, these were designed to protect individuals who needed protection against majorities who presumably would not, pardon my phrase, screw themselves by denying themselves these rights, but would turn around and deny these same rights to other groups. And that's what the dysfunction was in the minds of the framers. The fear was that majorities would be self-interested, and they would systematically disadvantage groups who were not adequately protected in the political process. And of course, this is true. I mean, human nature being what it is, this is a completely uncontestable proposition. And courts were designed to be a central way of protecting against that. Courts were supposed to be able to stand outside the majority and protect these vulnerable groups against intolerant majorities who misbehaved. The other thing that the framers were worried about, in addition to intolerant majorities, was capture. The other thing they worried about in democracy was that at any particular given point in time, one faction would take control of the levers of power. They would control the House, the Senate, and the White House, for example, in the federal government. And they would then enact laws to perpetuate their power. Again, human nature being what it is, if you're in power and you get the chance to keep yourself in power, you will do it. You'll do it either because you're cynical and manipulative or because you're simply introspective about why you happen to like certain kinds of laws and not others. But you can be sure you'll do it. And so that's the other major dysfunction in majoritarian democracy that the framers were concerned about, capture. And so in that situation, what you also want courts to be able to do is when they see a risk of capture, to step in and say those laws are unconstitutional. You can't make those laws. Okay, so in my view, that is an approach to the judicial activism, judicial restraint puzzle that basically says the best way to resolve that problem is to ask when are courts needed to be activist, to be muscular in their second guessing of the legislature. And the answer is when there's a good reason not to trust the legislature, not to trust the majority. And the two circumstances in which that distrust are most evident are those in which you've got a traditionally vulnerable and disadvantaged group and where you've got a risk of capture. Now, if you go back to the Warren Court for a moment, which was so much attacked by conservatives at the time and ever since, what's interesting is, as I suggested earlier, the best way to understand what a court is doing is not to read its opinions and not to listen to what it says, but to look at what it does and to look at the results that it reaches and to infer from those results what it's actually doing. So the example I gave a moment ago had to do with originalism. If judges purporting to apply originalism always reach the result you would expect them to reach if they didn't apply originalism, there's very good reason to believe they're not applying originalism, in fact. Right? So if you look at the Warren Court and you lay out all of the decisions the court reached from 1954 to 1969, and you divide them into two categories. There are the categories in which the court acted with restraint, and there were many of them, and there are those in which the court acted actively. And again, by actively what I mean is they didn't defer to the legislature. They said, no, the mere fact that you say that, not good enough. Right? In order to pass constitutional muster, you've got to prove to us beyond a reasonable doubt that there's a really compelling reason for doing this, otherwise it's unconstitutional. If you look at the decisions in which the Warren Court did that, were activists, every one of them, I say almost every one of them, but probably every one of them, falls into the two categories I mentioned a moment ago. They fall into the category of situations where the majority is disadvantaging a systematically oppressed group, whether it be African Americans in Brown v. Board of Education, or Loving v. Virginia, which held miscegenation laws unconstitutional, or political dissenters, people accused of communism, or religious dissenters, Jehovah's Witnesses, or persons accused of crime in cases like Miranda and Mapp holding the exclusionary rule, or Gideon v. Wainwright guaranteeing a right to counsel to indigent criminal defendants. Almost all of the decisions fit into partly that category, protecting minorities who are not likely to be given a fair shake because of who they are in our society, on the one hand. And on the other hand, cases in which there is a risk of capture. So protecting freedom of speech, freedom of the press, as a check against the government, limiting the ability of public officials to silence people who make false statements about them, one person, one vote, generally protecting the equality of voting, holding unconstitutional laws that provided that certain people couldn't vote. A good example of that today would be all of the laws that Republican state legislatures were enacting about ID laws, voter ID laws, which are clearly designed to capture. Right? The real purpose of those laws is to capture, to exclude from the franchise people who would vote the other way, on the pretense of saying that they're about fraud. So a a court approaching that problem from a restrained standpoint would say, okay, there's a rational justification for the law. Fraud's potential problem. If you can't present an ID, then the risk of fraud is greater. It's possible to go get an ID. It's not impossible, even if you don't drive. So it's a reasonable thing for the legislature to do. And a judge applying judicial restraint to that case would uphold it. A judge applying judicial activism to that case would say, wait a minute, what you're doing here is carving up the franchise. You're excluding a segment of the population from voting. Moreover, it's a defined segment of the population. It's the poor and it's minorities, wildly disproportionately, who are not able to vote because of voter ID laws. And therefore, there's a risk of capture. There's a risk of an effort to manipulate the political process. And so the fact that there's a potentially reasonable justification for it is not enough to uphold it. You've got to show that it's necessary to do this in order to serve a compelling interest, and that certainly isn't true here, and so they would strike it down. So that's an example of the difference between the two approaches. So the Warren Court's jurisprudence entirely fits within this, this approach that I've described. Acting, when do you need courts to be aggressive in interpreting and applying the Constitution? And their jurisprudence basically fits those two categories to a T. Even if they were not thinking in those terms, by the way, although they were. Because in 1938, after the court, or at the same time the court was rejecting conservative activism in the economic cases, invalidating all the progressive laws, at that time, in 1938, the court was thinking, well, what should we do about fulfilling our responsibilities? And in a very famous footnote 4, in a case called Caroline Products, Chief Justice Stone, no relation to me, basically stated the theory that I've been arguing for here, in saying that judicial restraint is the proper approach in general, but when we have these situations, courts need to be much more aggressive. And the Warren Court, 16 years later, picked up on footnote 4 and made that essentially the marching orders of its jurisprudence. Okay, so where are we today in the Supreme Court? Well, where we are today is a group of justices who, first of all, they're divided 5-4, as you all know. Sharp 5-4 division in the current jurisprudence of the Supreme Court. The 4 justices on the, quote, liberal side are really not liberals, they're moderates. They're not like William Brennan or William Douglas or Thurgood Marshall or Abe Fortas or Arthur Goldberg. They're much more moderate than those justices were in flexing their judicial muscles. But their inclinations tend to be more like the Warren Court. And when I say liberal now, I mean not politically liberal necessarily, but more like the Warren Court. And then there are 4 justices who are the 4 most conservative justices who have served on the court in the last 75 years. And this data comes from 2 of my very conservative colleagues, Dick Posner and Bill Landis, who has done a study trying to measure conservative liberal voting patterns among justices over the last 75 years. And they find Roberts, Alito, Thomas, and Scalia are the 4 most conservative who've served on the court in that period. And Kennedy is the 6th most. Rehnquist was number 5. So the swing vote on the current Supreme Court is the 6th most conservative justice to serve on the court in the last 75 years. Okay, so what is their jurisprudence then today? Well, one thing that's clear, it's not judicial restraint. This is not a court, none of the 9 justices is committed to judicial restraint at all. That's not across the boards their approach. 2 of the current justices occasionally invoke originalism, Scalia and Thomas, but Scalia has said he's a faint-hearted originalist. He invokes it occasionally, but not very often. Basically, the 5 are best characterized as conservative activists. What that means is that they are restrained, as the Warren Court was, in a broad range of cases, but they are selectively activist in a separate range of cases. In the Warren Court, I explained to you what the pattern was and why the Warren Court was activist in the cases in which it was activist. So the same question then arises, why are the 5 conservative justices of the current Supreme Court activist in the cases when they are activist? And as I said, the best way to do that is not to read the opinions, but to simply look at the results and lay them out and see what you learn from their actual behavior, right? And what you find is that these justices consistently reject constitutional claims, thereby acting in a restrained way by African Americans, by women, by Hispanics, by gays, by criminals, persons accused of crime, the traditional underrepresented groups. They almost never win for those 5 justices. But they hold laws unconstitutional in cases like the gun control law, affirmative action laws are unconstitutional, campaign finance regulation is unconstitutional, laws that regulate property are unconstitutional, laws that restrict commercial advertising are unconstitutional, and of course in the 2000 presidential election, the laws of the state of Florida are unconstitutional in Bush v. Gore. So if you look at that set of cases, what you have to sort of conclude is there's no theory, there's no principle that explains the pattern. And I've often asked my conservative friends, tell me what the theory is, right? Forget about originalism, forget about restraint, look at the results and tell me what explains the outcomes of these 5 conservative justices. And interestingly, they never get back to me. Right? Never, not one has ever gotten back to me on this question. But the reality, I think, and I'm quite confident in saying this, is that they are doing exactly what they accused the Warren Court justices of doing, who weren't doing it. That is, they are activists in those cases when they don't like the law. They don't like campaign regulation, unconstitutional. They don't like gun control laws, unconstitutional. They don't like affirmative action, unconstitutional. They don't like regulations of commercial advertising, unconstitutional. And the truth is, when you look systematically, not when you read the opinions, each individual opinion could be reasonable, but when you look at the systematic pattern, you can't help but conclude that what's going on is not principled, it's not originalist, it's not restrained, it's selective conservative activism, largely driven by exactly the kinds of personal, political, ideological values of the individual justices. I'll give you 2 concrete examples of this, and then I'll stop and open it for questions. These were examples I discovered long before I was thinking about this problem, and they came up in different contexts, but they got me thinking about this problem. The first was after Bush versus Gore. So I was curious in Bush versus Gore that Justices Scalia, Rehnquist, and Thomas joined an opinion holding the Florida law unconstitutional under the Equal Protection Clause of the 14th Amendment. So now I happen to think, in fact, that the majority opinion in Bush versus Gore on the equal protection grounds is a quite reasonable one. However, I was curious about why they thought it was a reasonable one, right? So I looked at every decision up to that point in time, in 2000, in which those 3 justices had voted on cases involving the Equal Protection Clause of the 14th Amendment. And there were 56 of those cases. Putting aside 19 cases involving affirmative action, there were 56 cases. In those 56 cases, these justices voted to invalidate the laws once. One vote in the 56 cases to invalidate the law. These are laws challenging inequalities by African Americans, by women, by gays, by Hispanics. Always constitutional, right? In the 19 affirmative action cases, oh, by the way, in those 56 cases, the other justices voted to invalidate the law 74% of the time, whereas they voted 2% of the time to invalidate the laws. In the 19 affirmative action cases, these 3 justices, Thomas, Rehnquist, and Scalia, voted every time to hold the laws unconstitutional. So what does the Equal Protection Clause mean to those 3 justices? Simply by looking at the results over a period of then about a decade. The Equal Protection Clause means that you can't discriminate against whites in affirmative action programs, and George Bush gets to be president. Everything else is okay. That's pretty scary. frankly. The second example of this, which I happened to come upon, was when after Chief Justice Rehnquist died, I was asked to write something about Rehnquist and the First Amendment. And I decided to do a similar kind of inquiry, just out of curiosity, I didn't know what I'd find, about Rehnquist voting in free speech and free press cases. And during his 34 years on the Supreme Court, Rehnquist participated in 264 non-unanimous cases. The unanimous cases are uninteresting, so put them aside. 264 non-unanimous cases. In those 264 cases, Rehnquist voted to invalidate a law on the grounds that it violated the First Amendment 8% of the time. His colleagues in all those cases, including Scalia and Thomas and so on when they were on the court with him, voted 56% of the time to invalidate the same laws. So Rehnquist was 1/7 as likely to hold a law challenged on the grounds that it violates the First Amendment as its colleagues on average were. Okay, that could be judicial restraint. Right? That might just be judicial restraint. That's not necessarily unprincipled. But then I went and I looked at the 8% of the cases in which he voted to hold the laws unconstitutional. And every single one of them fell into the following category. It was a campaign finance law limiting the ability of wealthy individuals or wealthy corporations to engage in unlimited expenditures to support their political candidates. It was commercial advertising cases. It was religious expression cases. And it was the Boy Scouts having, in Rehnquist's view, a First Amendment right to exclude gay scoutmasters. So his entire First Amendment jurisprudence never protected a political dissenter, never protected a newspaper, never protected the press in any way. It only protected corporations, wealthy individuals, commercial advertisers, religion, and the Boy Scouts in 34 years on the bench. So it's not deference, it's not restraint. He's clearly willing to be activist, but only in those odd collection of cases. Okay, so the net effect of this is that the Supreme Court can and should serve a fundamental role in maintaining our democracy by policing the political process to ensure that it operates fairly with respect to those groups that have been historically disadvantaged in the process and not given a fair shake, and to guard against capture. And what we have in the current Supreme Court is no philosophical approach, no theory that explains the results, but instead, essentially, a raw exercise of ideology. And what's really scary about this to me is not just their behavior, but the fact that the American public have no real understanding of this at all. With Citizens United, you got some people who were increasingly upset because that was an unpopular decision. But for the most part, most Americans believe that liberals are activists and conservatives are passive. They just call balls and strikes, as Chief Justice Roberts said in his confirmation hearings. They engage in something called strict construction. They believe in passivism, none of which is true. But it's absolutely the way conservative politicians have successfully manipulated public discourse so as to create that understanding. And the consequence of that is conservative presidents, Republican presidents, are able to nominate and appoint very conservative judges and get away with it. And liberal presidents, Clinton and Obama, are not able to do the same because the political ramifications of it are completely twisted. And so that then self-perpetuates itself in our political and judicial system. Okay, with that, I will stop and take questions. Thank you.
Your scenario is pretty scary, and I think we've all felt the same way, but do you think the system is broken, and what would be required to fix it?
Good question. Is it broken? Yes. The entire political system is broken. This is just one part of it, of course, right? What will it take to fix it? That's a great question, of course. In the first instance, I think the greatest danger to the political system at the moment is money. And unless we can find some way to fix that, I don't think any of the rest of it is likely to get fixed anytime soon. So that's a very large problem. Focused more specifically on this, I think these justices, some of them at least, are conscious of criticism. I mean, one thing judges balance two things when they're on the court, particularly Supreme Court justices. One of them is doing what they believe to be the right thing. And none of these justices is insincere. None of these justices is deciding cases because they consciously are thinking, I am going to abuse my authority and reach what I believe to be the right political decision or the right policy decision without regard to my actual constitutional responsibilities. That's not a fair characterization of any of them. They all subjectively, case by case, believe they are applying the Constitution in a principled, natural, appropriate way. And again, it's only when so each case by case, you can look at each case and you can argue about it, but it's not crazy in any of the decisions, right? I'll give you an example, Citizens United, okay? So Citizens United is a case which actually the Warren Court, I think, would have been probably in the same position as the conservative majority in Citizens United. Because the law in Citizens United, the Bipartisan Campaign Finance Act, is a perfect capture problem, right? What it's doing is you've got elected officials who are passing laws to determine the process by which they and their successors get elected. Talk about fox in the hen house, right? So you could be sure of two things. If one party happens to control the House, the Senate, and the White House at the time that they enact campaign finance legislation, it's going to benefit their party. There's no possibility that that's not going to happen, right? And they will be pretty good about doing it, so it's not obvious that it's going to have that effect. So judges who defer will make a mistake. Judges who defer to that legislation will assume that it's meant to serve the purposes that it's defended on, when in fact it's meant to manipulate the political process and assure the perpetuation and authority of the party that adopts it. So deference in that case would be very dangerous. Even if the law is bipartisan, as the McCain-Feingold Act sort of was, there's still the obvious danger of self-perpetuation of incumbency. Right? Incumbents are not going to make laws that are going to threaten their own incumbency, their own re-election. And as Justice Scalia, in an opinion, Citizens United, aptly described the 2002 law, is that it's an Incumbent Protection Act. After all, who's going to be disadvantaged by no money in the political process? Right? It's going to be challengers, on average, because incumbents have name recognition. Right? So if nobody has money, the incumbents win. And so then whether that's true or not is another matter, but it's a real concern. So the Warren Court would have said, I believe, in faced with that legislation, we can't give any deference here. We have to be absolutely certain this law is necessary to serve a compelling purpose of preserving our democracy, and that unless the government can prove to us that it was necessary, we can't allow you to do this, because the risk of capture is too great. And the reality is, I think at the time of Citizens United, the government's defense of the statute was reasonable and pretty strong, but maybe not enough to get past the argument that this is too problematic to allow the government to have this power. I think actually today, a couple of years later, it's much easier to make a compelling case that the worst fears are proving true of allowing corporations to be free agents. Although the biggest problem, frankly, right now is not corporations, it's individuals. And they've been held to have a constitutional right to spend whatever they want now for 35 years. So what do you do about that? Justices don't like being criticized. They care about their legacy a lot. And I do think that criticizing justices does have a significant impact on making them think twice about what they're doing to the institution of the court, which they worry about, and to their own standing in history. So I think strong criticism of the court has an effect. And it has an effect in a couple of ways. It has an effect on the justices themselves. It also has an effect on presidents who are going to appoint judges, who will be more reluctant to appoint judges who will be controversial and may require them to spend a lot of chits. So Obama, for example, has been very reluctant to spend any chits on his judicial nominees. Conservative Republicans have managed to turn the political process in a way that Obama knows if he appoints somebody who says, I'm a liberal, right? You could say I'm a conservative, right? John Roberts, I'm a conservative, and nobody questions, well, how bad are you, right? Are you crazy? But if someone says they're liberal, they're dead meat, right? So part of it is reversing that and figuring out how to change that discourse in an important way. Yes?
Hi, I had 3 questions. I liked this thesis you came to about what is the legitimate role of the courts. And particularly in your deconstruction of the originalism justices, I was reminded of another U of C scholar, Bernard Harcourt. He seems to be making a similar point about economic markets, that this idea of the invisible free hand of the market, that idea has masked what is the true effect of the policies which we have. And you're kind of, I think, saying a similar thing, that this idea of originalism obfuscates what is the actual result, what are the actual votes that these people are making. So I just thought that was interesting.
I don't think actually Bernard and I are making points that are quite so similar.
Well, in totally different spheres, but I think.
No, but even the arguments I think are quite different actually. But
okay. Yeah. Well, I would say that there possibly what you are both fighting against is maybe the same conservative element in our zeitgeist.
Well, that's true.
From the Chamber of Commerce in the 70s.
That's certainly true. Right.
You're both arguing against the lies that they've created. And then the question element is, I would ask you to speak a little bit about, we had the sit down, shut up ordinances passed here in Chicago. I was very involved in protesting against them. We were told by the National Lawyers Guild and the ACLU after they passed, Occupy Chicago was told that they were not going to front they were not going to fight them in the courts because it was consistent with all of the erosion that has already taken place on the First Amendment. Essentially, the sit down, shut up ordinances in Chicago are the nail in the coffin. It is impossible for someone that the city does not want to protest lawfully with full due protection of the law. That is completely gone now.
Yeah, is there a question there? Is there a question?
We were told by the ACLU.
Is there a question?
Do you buy what the ACLU and NLG said, that you can't fight on the First Amendment anymore? It's eroded so far, and then what would you do?
You could certainly fight on the First Amendment in many contexts, and people do all the time. In this context, I think their judgment that these laws are probably constitutional is right. And I think it's not necessarily because of some terminal erosion of First Amendment law. I mean, it's been well established for a very long time that government's allowed to regulate the means of the communication in a time, place, and manner way, as long as there's a reasonable justification for it. And the reality is laws of that sort are generally upheld unless you can prove the very difficult thing to prove, that it's specifically intended to silence a particular point of view, and it wouldn't exist otherwise. In this case, that's a case you could believe, but it's not so hard, not so easy to prove in a court of law. So I think their position, I think their position is probably right on the meaning of the First Amendment. Yeah. And I'm an ACLU type, but that's.
Comment a little bit about the fate of footnote 4 and how.
The fate of what?
Footnote 4.
Yeah.
What did the Warren or the Warren court explicitly refer back to that as you did?
So the question is, what was the fate of footnote 4? Yes, but only sporadically. I mean, they did not make that the centerpiece of their decision making. But it was not obscure. It was well known. So you didn't have to cite it. It was well known from the time it was handed down. It's the most famous footnote in American law, so I think the answer is, I think it was in the air they breathed, and so they didn't need to invoke it so often because they understood what they were doing, at least in the general sense. Right, but they didn't literally invoke it a lot.
It's questions real quick. There's just 2 little bits. First of all, this may be sophomoric, but doesn't the Second Amendment say the existence of a militia being necessary for freedom, whatever? Therefore, there's a right to bear arms. Wouldn't the originalists say, well, we don't need militias anymore? And then the other thing is, you say something about corporate personhood, should I be scared?
Okay, so in terms of the first question is about the Second Amendment. The Second Amendment says in order to preserve a well-regulated militia, the right to keep and bear arms shall be preserved. And the question is, what do you make of the preamble, right? What do you make of the introductory clause? So one argument is that the only purpose of giving, no other provision of the Bill of Rights has a preamble. So it's a kind of unique problem. So one way to interpret it would be to say that you only have a right to keep and bear arms in order to have a militia. But we don't need militia anymore of that sort. We have police departments. And so when you own a gun in your home, it has nothing to do with a militia, right? You're owning it for your own purpose, whether it's your own personal self-defense or a hobby or whatever, but it's not really part of the state's need to have a militia, as it was at the time the Second Amendment was enacted. And so one reading of the provision, which is what the four dissenters in Heller took, is that the right to keep and bear arms was limited by the preamble, and therefore the gun control laws in general don't have anything to do with that and don't implicate the Second Amendment. The justices in the majority took the view that the preamble was simply saying this is a reason for having the right of the people to keep and bear arms, but not necessarily an exhaustive one. And they then dig in, and this is where you go into the history, and you can find a variety of different inconsistent comments by the framers. There's no way to, the reality is there's no way to answer the question from a historical standpoint, and although both opinions try to use history. The text seems pretty clear that it's about militia, not about having a gun for the sake of defending your home or shooting. But you can argue that the right to defend your home is what a militia does, and it's really the same thing. And but yes, I mean, that text is an embarrassment to the justices in the majority in Heller, but they were determined to reach that result. Right? The second question was
Corporate person.
Oh, okay. So this I believe is a red herring. Citizens United has been challenged on the grounds that corporations are not people, and what's the Supreme Court doing? Okay. The First Amendment provides Congress shall make no law abridging the freedom of speech or of the press. It says nothing about people have rights. Right? It's a restraint on Congress. So it's not as if the question of whether a corporation is a person was in any way, shape, or form before the court. Nobody in the Supreme Court on either side thought that was an inquiry of any relevance to anything. Right? The question was, can Congress pass this law? Not whether corporations are people. And it's only after the decision, really, although I shouldn't say that, the argument that corporations are not people and don't have rights goes back long before Citizens United, but no justice of the Supreme Court on either side of any of these cases that stretch back over 35 years has ever even thought that to be a sufficiently serious question to respond to or to invoke. Okay? It's just not a real legal question. It's public, discourse. On the other hand, it is reasonable to say, are corporations different in ways that make it appropriate to restrict their rights that would not be appropriate for individuals? So the question is not the definitional one. Is a corporation a person? It's, does it abridge the freedom of speech for the government to restrict corporations in a particular way? Right? And there the argument would be that corporations are different from individuals in a whole variety of ways, but one of the ways in which they're different is they're given certain powers that are unique to corporations. They're artificial entities created by the state. They're given certain powers which enable them to accumulate huge amounts of wealth relative to most individuals. And the state has never given them those prerogatives, those immunities from various taxes and so on, in order to let them participate or to dominate the political process. It was to enable them to participate effectively in the economic process. And that because they are artificial entities, they can be regulated in ways that individuals cannot be regulated. So the way to frame the inquiry is not are they people or are they not people, it's can the state legitimately regulate them because they are different from people. And there's all sorts of situations where issues like that arise. Do immigrants have the same rights as citizens? Do aliens who are overseas have the same rights as people in the United States? Do criminals in jail have the same rights as people who are free? We frequently ask those questions. The question is not, is a criminal a person? The question is, if you're in prison, do you have the same right to get mail uncensored as you and I do? Right? So that's the right way to frame that question.
Assume, for my question, that you're sitting on the Supreme Court. How would you rule on the Affordable Care Act, and if it was to affirm, what would your reasons be? Or if it was to reverse, what would your reasons be?
So, okay, I think the Affordable Care Act is an easy case. I think it's an easy case both based on the precedent and based on the approach to constitutional law that I was laying out. In terms of the precedent, it's very clear that the court over the last 75 years has adopted a very broad interpretation of the Commerce Clause. Let me go back and explain what the issue is. Okay. So the issue in the Affordable Care Act case is this. The state of Massachusetts or the state of Illinois could constitutionally enact exactly the program that the United States government has enacted in the Affordable Care Act, and it would be constitutional, absolutely no question. Okay? There's nothing about the act itself that would violate any of the ordinary constitutional rights, like freedom of speech or freedom of religion or equal protection or any of those things. So the state of Illinois could adopt the exact same law that the Congress enacted, and it would clearly not violate the Constitution. So the question then is, well, why is there an issue in this case? And the reason there's an issue in this case is because it was enacted by the federal government. So the difference between the federal government and the states is that the states have plenary authority. They can do whatever they want unless their actions violate either the state or federal constitution. So the state of Illinois cannot pass a law that says African Americans can't attend public school. Right? That would violate both the state and the federal constitution. But unless it does something that explicitly violates the limitations imposed upon the state, it's free to do it. The federal government is a government of limited powers. Right? When the framers created the Constitution, they wanted the states to be the primary agencies of sovereignty. Right? They were the governments of the people in the day-to-day lives. The federal government was created to serve the interest of the nation at large. And therefore, it can only exercise those authorities that are delegated to it in the Constitution itself. Okay, so then the question is, if you want to adopt the Affordable Care Act, with any federal law, you've got to ask yourself, what is the constitutional basis for the federal government enacting this law? Okay, and so for the Affordable Care Act, the answer to that question is the Commerce Clause. So the Constitution gives Congress the power to regulate commerce between the states. And the reason the framers of the Constitution gave Congress that power is they didn't want Illinois having a tax, for example, on Indiana products. They wanted one nation. So they wanted to give the federal government the power to prohibit those taxes. Or they didn't want Indiana building a railroad with a different set of rails than Indiana. So trains couldn't go from one state to the other. And the federal government could therefore require uniform rails. So the idea was to give the federal government the power to regulate interstate commerce to enable it to flow smoothly across the nation, rather than let each state do it internally, which could create chaos. Okay, so the question then is, well, how far does that go? Right? How far does the Commerce Clause allow the federal government to go? Until the New Deal, the Supreme Court interpreted the Commerce Clause much more narrowly than it has since then. So the federal government did have the power to pass laws, but they tended to be things like regulating railroads. That was sort of the paradigm of what federal regulation under the Commerce Clause was. With the New Deal, the court for the first time recognized that economic decisions within a state can have implications across states. So even if you're not shipping a good from Indiana to Illinois directly, if you're making a good in Indiana, it might have effects in Illinois. So you may be making it in Indiana, but you're buying nails that were made in Illinois. So we can regulate not just the nails going across, but what you do in Illinois, because you're using nails from Indiana. So the New Deal basically took a much broader view of the Commerce Clause. Okay? The next iteration of this was the Civil Rights Act. So a restaurant in South Carolina refuses to serve blacks. Okay? This does not violate the United States Constitution itself, because the United States Constitution says no state shall deny any person the equal protection of the laws. If the state of South Carolina refused to allow blacks to eat in restaurants, that would violate the Equal Protection Clause. But a private owner of a restaurant is not governed by the Equal Protection Clause, which only says no state shall not do something. So Congress passes the 1964 Civil Rights Act, right, which says that our restaurant owner cannot discriminate in service against blacks. And it's defended on grounds of the Commerce Clause. And the Supreme Court holds that it's constitutional because what the restaurant does is bound up with interstate commerce. Now you can see how attenuated this is getting, right? And so the federal government's allowed to prohibit you as an employer from refusing to hire blacks because you as an employer are engaged in business which has some attenuated effect on interstate commerce. And that's sufficient. So over time, and part of this is because we got such an integrated economy now, that to try to go back to the pre-1930 world would make the government and the nation completely ineffective. Okay, so given that background, now you've got the Affordable Care Act. Okay, it's an easy case. Okay, this is regulation of activity that has enormous impacts across the nation in the healthcare environment. And when the act was adopted, nobody thought it was unconstitutional. The arguments about it in Congress nobody argued it was unconstitutional. They argued it was bad policy, right? Which it might or might not be, but nobody argued that it was unconstitutional. After it was enacted, some libertarians, friends of mine actually, came up with this notion about the individual mandate being problematic. And their argument was that the individual mandate is problematic because it does not regulate actual activity by anybody. What the individual mandate does is require you to buy insurance if you don't have it. And so their argument is, well, that person that you're requiring to buy insurance has done nothing. There's no activity that affects commerce at all. It's not like the restaurant, right? This person's sitting there minding his own business. He's not doing anything at all that has placed himself in the realm of interstate commerce directly or indirectly in the realm of healthcare. He just hasn't bought insurance. It's like you decided, to go through a red light. It doesn't affect interstate commerce. So their argument was that you've got to draw the line somewhere with the scope of the Commerce Clause. And this is the place to draw the line. Because if the government can require you to buy health insurance, even if you don't want to, then it can require anybody to do anything. And this is where it can require you to buy broccoli comes in, right? So the argument is that if you can require individuals to buy health insurance, you can require every person to eat broccoli once a day. The federal government can require, the state can do it, by the way, but the federal government would then have the power to require every person to eat broccoli once a day. Why? The federal government says, well, broccoli production is good for the country. So everybody has to eat broccoli every day under the Commerce Clause, right? So that's the argument that's being made. And the truth is, it's a totally disingenuous argument. We require people to do things that are inactive constantly. The owner of the restaurant is being required to serve blacks, right? He says, all I'm doing is not serving blacks, right? Like not buying insurance. I'm not doing anything, I'm just not serving blacks. And so to make this fuss over activity, inactivity is not a terribly persuasive line to draw. So for me, it would be an easy case. I would say it's constitutional on the basis of the precedent. And there's no obvious reason why you need to change the precedent here. These decisions have dramatic impact on interstate commerce, in fact. Because the decision of individuals not to buy insurance affects interstate commerce in two ways. They tend to be people who self-select out of insurance because they need it less, which means that affects the rates of everybody else. And then, of course, when they get in trouble, they go to the hospital and they demand to be given health coverage. And our society being what it is, we don't turn them away and say, you don't have health insurance, so you got to die on the street, right? And so the effect of those 35 or 36 million people who don't have health insurance, who would be required to buy it under the Affordable Care Act, is $40 billion a year on interstate commerce. That's a lot of impact on interstate commerce, right? So it's an easy case, and it should be an easy case. Before the oral argument, my own prediction was that it would be at least 7-2 in favor of upholding the act. I thought maybe Thomas and maybe Alito would be willing to say, Commerce Clause jurisprudence is just wrong. We've got to wind back the clock. It's not that this case is different from the other cases. It's that it was wrong and we've got to change the law. I thought those two might be determined enough to be willing to do that. But I didn't think that the other conservatives would. After the oral argument, I don't think they'll do that, but I do think they may well latch on to this silly argument about the individual mandate and hold it unconstitutional. And again, to go back to my own approach, of course there's no need here for judicial intervention in any activist way. There's no historically oppressed minority here that's being disadvantaged. This is not a capture problem in the political process. This is something where if enough people don't like this law, they can change the law through the democratic process. That's what the democratic process is for. There's no need for courts to step in and intervene here. And therefore, I would say on both counts that the way I would vote is to uphold the legislation. And that's what the court should do, clearly, I think, in this case. No, they had to take the case for two reasons. First of all, the lower court's divided, and one of the responsibilities of the Supreme Court is to have a unified set of law in the United States. So when different courts have reached different results on a matter of consequence, they really have to resolve it. So they should have taken the case, yeah.
Couldn't you make the same argument about Social Security?
Meaning that it's unconstitutional for that reason?
Yeah, you know, nobody was doing anything.
Okay, it's a complicated answer. Social Security is a tax. The federal government has the power to tax you. That's a different power than the Commerce Clause. That's why you heard, when you read the reports or if you listened to any of the oral argument, there was discussion about is this a tax or not. And if it were truly a tax, then it would be constitutional. So if all of us were taxed to pay for health care, and then we got a tax credit for the money we spent on health insurance, that would be constitutional, because that would be government taxing. Because this is structured the way it is, and again, the reason they structured it this way rather than as a tax is because they didn't think there was any constitutional doubt about it. So there was no need to even think about this question, about which way you structured it. But they structured it the way they did, A, because it was much simpler to do it this way, in fact, rather than have everybody have a tax credit and have to go out and buy insurance and get it reimbursed by the federal government. But so it had been a tax, this would have been an easy case. And that's another weirdness of this situation, is that the government could have achieved the same objective, absolutely, by simply framing it as a tax on everybody.
You started off by asking the question about why do we need the courts? But it seems you're talking a lot about how do these type of people make decisions? Do we know how they make decisions? Do they publish transcripts of their discussions at some future time that scholars like you investigate? What is the transparency for understanding decision making for future generations?
So the question is, to what extent do we have knowledge of the actual process by which justices decide cases? And the answer, of course, is that's very much behind a veil. So their proceedings are confidential. It's by their law. They don't let anybody in. I mean, it's their court, it's their building. Could you pass a law? It would create an interesting separation of powers problem. But it would be like television in the Supreme Court. If the Congress passed a law that required television in the Supreme Court, the court would probably say it's unconstitutional on the ground that it intrudes upon their authority to manage their own branch of government. Separation of powers argument. But in any event, so no, you really couldn't pass a law, certainly about the internal workings of the court. So the tradition is that it's confidential, and the justices take that very seriously. I was a law clerk to Justice Brennan, so I spent a year inside the court. And the general reality of the way the court operates is the justices will hear a set of cases, oral arguments, and a set of cases Monday to Thursday, 2 weeks a month, usually 3 cases or 4 cases each day. At the end of the week, they will meet, the 9 justices will sit down and meet in conference. and they will then vote on those cases that they heard argument in that week. And the conference is an opportunity for the 9 justices to discuss the cases together, orally. There's no formal record is made of any of that. There's no transcript, certainly. For the most part, those conversations are perfunctory. The justices tend not to be very open or candid or interactive with each other in that setting. Is that tradition? The tradition developed when Justice Douglas was on the court. I'm sorry, when Justice Frankfurter was on the court. A former professor, as a former professor, he always would decide to lecture the other justices in conference. And Douglas was so pissed off at this that he would walk out when it was Frankfurter's turn, and he'd say to the Chief Justice, "Let me know when he's done." So the tradition has sort of become, you keep it short, right? And so there's a little bit of discussion there, but not a lot. But then they go back, before they go to the conference, they might talk to one another individually, right? Justice X may call Justice Y and say, "What do you think about this case?" And they're perfectly free to have those conversations, and depending on their relationships with one another, they do have them. But they're more cautious than you might expect. I mean, these are people who are openly disagreeing with each other in matters of great consequence, accusing each other of being thoughtless or wrong-headed or whatever. So they're pretty sensitive to the nature of their relations with one another. They try to be. The clerks play a much more important role there. The clerks basically are the people the justices talk to very candidly, their own clerks. Each justice today has 4 clerks. And the clerks, they serve for 1 year, the young law school graduates. And the clerks will talk to each other across chambers. Now, how much of that's preserved? It's entirely up to the individual justice. So what Justice Brennan did, my justice did, is he would take notes in conference, and he would discuss with the clerks right after conference what each justice said, and what the deliberations were, and what the vote was. And then during the course of the term, the clerks would write case histories. They would draft case histories of any of the cases that Brennan wrote an opinion in during the course of the year. And rarely in any major case that he didn't write an opinion in, but where he played an influential role in the decision. And those case histories were then edited by Brennan and locked away in the National Archives. And when I was there, Brennan said they'd be available 25 years after the death of the last justice with whom I served, which still hasn't happened. All of the justices with whom Brennan served are now, no, O'Connor's still alive. She's the only one who's still alive. So it'll be 25 years after the death of O'Connor. So you're talking way in the future, right? Some justices have been more open than that. And Harry Blackmun, for example, left his papers open pretty much right away. But what's in the papers, it varies. Yeah, but so the bottom line is you don't get a lot of real detail. Clerks will often talk later, 10 years later, 15, 20 years later, especially after the justice is dead, about their recollections of things. But they're not allowed to take any papers or anything like that from the court itself. So it's pretty obscure.
So if it's obscure, then your statement that they're sincere in their belief of originalism is supposition.
No, I mean, I base that on my knowledge of the individuals and my dealing with them in a whole variety of settings. And yeah, no, I don't doubt for a moment they're sincere. All of them, even in Bush v. Gore, I have no doubt they were being sincere. This is how they're trained. This is what they regard as legitimate. It's how they do their jobs. I don't know what quite the analogy would be for you as a doctor, but it would be knowingly and intentionally doing something that's not in the interest of the patient. Right? You don't do that. Right? That's pretty much the same as these justices. Now, you may not be right about what's in the interest of the patient, and they may not be right in their interpretation of the Constitution, but they're trying to do that with the same degree of professionalism that you try to do it in treating a patient.
Where are the challenges to the voter ID laws? Was there one ruling already on Indiana's, and are there different approaches to challenging?
One of them was held constitutional a couple of years ago. I don't remember which state it was from now. Might have been Indiana's. And the court basically said there's a reasonable grounds for it and it's constitutional.
There was not a demonstration that there was really no fraud.
It was enough to say that it's a legitimate interest to prevent fraud, and this is a reasonable way of preventing it.
And are there other cases?
There are other cases pending trying to raise different twists on that.
That's what I was
Right.
wondering. If there's a different.
Right, but I don't think they're going to go anywhere. That's my guess. Not because of this particular court. Right.
Congress has been trying to enact some laws with regard to the internet, and fortunately.
Who's been trying to?
Congress.
Oh, Congress, okay. Okay.
Our Congress.
Yeah, well, there's the Tigris, Euphrates, and.
They've been trying to pass some laws with regard to the internet, basically create some form of filtering. Do you see the courts getting involved in this somewhere down the road?
Supreme Court has taken a very strong pro-free speech stance in holding unconstitutional laws about filtering on the internet. If you mean filtering content, offensive content, yes. Congress passed a law in 1992, the Child Online Protection Act, which prohibited obscene, forget the word obscene, indecent material on the internet that might be available to minors. And the Supreme Court held it unconstitutional flat out. Then Congress passed a law that made it unlawful if you have material that is obscene for minors. Now, obscene for minors is complicated. The First Amendment has been held not to protect obscenity. Obscenity is a very narrow today category of expression, of sexual expression, extremely explicit. It's so narrow now that nobody even bothers prosecuting for it, but it still exists. But there's also a category of obscene for minors, which is somewhat broader, which is basically when you go into a bookstore and there's a section for only minors, right? That's because you can regulate the speech minors can have, even if you can't regulate that same speech for adults. Okay, so the Congress enacted a law which basically said if you have material on the internet that would be obscene for minors, you have to have an ID verification requirement to allow people to have access to it. So if you want to put up a pornographic video, right, that let's assume would be obscene for minors, you can't allow anyone to have access to it who does not demonstrate that they are over 18 years of age. Now the problem is, how do you demonstrate you're over 18 years of age on the internet? We don't have a technology right now yet that does that. So the statute was actually very generous. The statute said if you type in a valid driver's license number or a valid credit card number, that will suffice so that the person who has put the website up will have a defense to any claim. So if a minor does get in, if that minor typed in a valid credit card number or a valid driver's license number, then there's no crime. Okay, so it was a very bending over backwards to protect the website operator. So it was, think about movie theaters. Right? A movie theater can keep children out of certain movies that adults can see. And the movies that can keep children out of are those that are obscene for children. And you do require the person who runs the movie theater to screen for age, either by looking at the person or by asking for ID. So they were trying to replicate that on the internet, right? And the Supreme Court held it unconstitutional. The Supreme Court said that in the internet, people who are interested in seeing sexually oriented material that could be prohibited for minors will be chilled from doing so if they have to give information about themselves, which, given the nature of the internet, can be stored and recaptured later by others, and that therefore you cannot shield minors from that material. So the court's been extremely protective of free speech in that realm, including at least Justice Thomas, who's been very protective of that, and even occasionally Justice Scalia.
How, in your view, how secure is Roe v. Wade?
Who's the next president? I think as long as Justice Kennedy is on the court, he's unlikely to change his view, which was to tolerate Roe v. Wade. So there'll be 5 justices to uphold Roe and only 4 to overrule it. Those 4 would certainly overrule it. If Mitt Romney were elected president and Ruth Ginsburg, for example, decided to retire or health precluded her from serving on the court, then you can imagine a battle royale over that. And we've had that battle before, and the justices who people thought were going to vote to overrule Roe, like Kennedy and Souter and Stevens and O'Connor, most of them have ultimately decided to preserve Roe. But that's obviously going to be a major battle at the time. So there's no guarantee that someone you appoint thinking they will vote to overrule Roe or sustain Roe would necessarily do it, because they are free agents and they can change their minds over time and so on. But yeah, that'll be a big battle.
But you think the 4 votes against are pretty certain?
To overrule? Oh, absolutely, yeah. Yeah, they've all made clear that, so I don't think there's any question about it.
Do you think that the justices should stay on the Supreme Court to the bitter end? Yeah.
Well, okay, so that's a good question. In other words, should they stay till they die? Justice Marshall, when I was on the court with Brennan, Marshall used to tell his clerks, if I die, don't tell anyone. This is when Richard Nixon was still president. Just wheel me out there, just don't tell anybody. So there's 2 elements of the question there. Should an individual justice who is sitting on the Supreme Court, who take into account in making a decision whether she should resign at a particular time, who the sitting president is, or who it might be? I think it's inescapable that they will. So it doesn't matter what I think. They absolutely understand the importance of the appointments process and will never intentionally put themselves in a position where they get replaced by somebody who will destroy everything they work for. On the other hand, the temptation not to resign, for a whole variety of emotional and psychological reasons, is great. And it's frequently the case that justices stay on longer than they should from this perspective, right? That as Ruth Ginsburg is at the moment. I mean, if Ruth Ginsburg a year or 2 ago had decided to step down, it would have given Obama the opportunity to replace her. And the fact that she decided to stay on, for whatever personal reasons of her own, now creates a risk. So the truth is, justices aren't very good at carrying out what they absolutely mean to do by their own self-interest, because their fears of mortality and indispensability get the better of them. Now, the other side of the question, though, should we have a situation in which it's up to justices to make those decisions? So there's been a lot of movement lately towards enacting legislation that would limit the terms of justices. And the most popular one among experts, really, is one that would basically say that we should phase in a system in which justices can only serve 18 years, and they all serve on rotating 2-year starting points, so that every 2 years a justice would have to resign and a new one would be appointed. And the idea is 18 years is enough for anybody. And this would mean that the outcome of elections has a little bit less of an effect on the vagaries of who dies when who's in office, and would make it a more orderly process. The objections to that, I think, are twofold. One of them is that you want justices never to have to think about their next job. If they have to think about their next job, you're in trouble, because you've undermined their independence, and that's a problem. So the difficulty with an 18-year period, if you're a justice and you're appointed when you're 46, as Roberts was, or even younger, then 64, you can still make a lot of money, you can still do lots of things. And so that's a problem. It distorts what now is a real independence by giving them careerist views, options. And the second concern about that is, it's my view, and experience certainly shows, that over time justices tend to get more liberal. There's good data on this, and it basically shows that if any given group of 8 justices who change in their ideology over the course of their careers, 6 of them move to the left and 2 of them move to the right. And so if you believe that a court is better if it has more progressive justices, then getting them out more quickly actually is a disadvantage. Now this is a totally self-interested political view of the problem, of the question. Now you might ask, why did justices become more liberal over time? And I think the answer to that is clear: they gain wisdom. I'm serious about that, because what happens to them over time is they gain a much better appreciation of both the realities of our society. Because a part of the Supreme Court process, which is invisible to most people, is the certiorari process. What that means is every year there's 10,000 cases that seek review in the Supreme Court of the United States. And the court agrees to hear less than 1% of them. But the court has to screen those other 9,920 cases. And the justices spend a meaningful amount of time going through them. And by seeing all the things that exist in the lower judiciary, they really get a better understanding of the deficiencies in the legal system. And that tends to make them more sensitive to the injustices that exist in society than they might otherwise get reading only the Wall Street Journal. And that actually has, I think, an educative effect. Justices like Blackmun and Powell, I think, became more liberal over time, in part because of that. And the other effect it has, I think, is they begin to understand how important the Supreme Court's role is in protecting those interests in our society. And so it is very much the case that justices tend to move to the left over time, in general. And if you think that's a better position, then cutting off their education process is not so good.
Is it Justice Thomas who has not spoken from the... Is there an interesting backstory there?
Not that I know of. Thomas on the Court of Appeals, as a judge, to my knowledge, asked questions in a normal way. I know Thomas a little bit, not well, and he's a relatively normal person if you meet him. I mean, there's no reason to think he'd be odd in any way, shape, or form, let alone like that. I was with Justice Scalia recently. He was a colleague of mine at the University of Chicago Law School for a number of years, and he was in town to speak at the law school. So we spent some time together. We talked about Thomas in this regard. And he said, he's basically tried to persuade Thomas to stop this, because it simply makes him look odd, and that's not a good thing for him. And he's not so odd, so why do this, right? And Thomas's view is that he doesn't think it helps him. He listens to the argument, he listens to what the other justices ask. He personally doesn't find it helpful to ask questions. It's odd, but it's weird.
Who's one of the more criticized justices on the current court?
By whom and for what?
In general.
Well, Thomas is the one who probably is regarded as the most, somewhat unfairly, I believe, by the way, but as the least able and the most knee-jerk, reflexive ideologically. I think both of those points are not accurate, actually. I think Thomas is more able than people give him credit for. I think his particular judicial philosophy is quite idiosyncratic, and I don't think much of it, nor do most of his colleagues in some cases, including some of the conservative colleagues. But it's interesting, and it's independent, and it's his own, and he defends it intelligently most of the time, not always. But he's the one I think clearly gets the most criticism. He's the most conservative of the nine, in most cases. Scalia gets a lot of criticism because he's so outspoken. He's sort of the opposite of Thomas. Scalia will tell you what he thinks about almost anything, often when it's inappropriate. So he gets criticized for that. I don't think any of the liberal justices get castigated so much. I mean, they're more moderate, even though they're liberal. So they're not like, they don't set themselves up the way the former generation of liberal justices like Marshall and Brennan and Warren, the group I mentioned earlier, Douglas, did. So, they're actually pretty cautious individuals. So they don't wind up being attacked by the right all that much. So yeah, I would say Thomas is probably number one and Scalia is number two.
Do you have any thoughts on the caseload or the workload the Supreme Court's taking? The number of cases they're deciding has gone down quite a bit over the years.
Well, it's a bit of a mystery to me, but so the reality is, when you take such a small percentage of cases that you're asked to take, it's easy to keep looking for the most important ones. So it's a little bit like, when you're grading exams, the best exams, the A's, really look different from the others. And it's a bell curve, but when you're way off on the tip, those cases on the tip look pretty different. They're pretty unusual. And so now Rehnquist, when he was Chief Justice, he wanted to cut back the workload. The court used to decide about 180 a year. So now they decide a little less than half that many. Rehnquist felt the court was spreading itself too thin. It was not having enough time to really adequately deliberate over many cases, that it was wasting a lot of judicial energy on cases that weren't all that important. And so he pushed hard to cut the workload at the court. It's mainly that they don't decide cases which wouldn't make headlines. So it's not like, the cases they're not deciding are not cases that you miss as a citizen. You wouldn't be aware of them in any event. They tend to be, a tax case or an intellectual property case or whatever. But the cases that are important cases that need to be decided, they're not exercising any particular discretion there. They're basically taking the A pluses and not the rest, whereas the court used to take the A pluses and the A's in terms of the importance of hearing the case. You have time for one more question?
Comment on the history of the judicial selection process and how it has gotten to where it is today, and that be modified to the benefit of the country.
So the question is about the history of the judicial selection process and the nomination and confirmation process, and how's that changed? So I actually wrote a piece for the Supreme Court Review, which is a scholarly journal, on this question during the Kagan nomination, because I was interested in it. I did a lot of empirical work to try to figure out what's changed and what hasn't changed and so on. And I'll give you a couple of observations from that. The first one is the Bork nomination, which people think changed everything. It did not. In the nominations that happened after Bork, there was not any significant difference in the behavior of the president or the Congress than the way they behaved in cases before Bork. There has been a dramatic change, interestingly, from 2000 to the present. And the best way to illustrate this is with this example. For the 30 years before 2000, there were a dozen nominees to the Supreme Court who had three characteristics. They were regarded as capable. They were regarded as ideologically relatively moderate, not extreme. And their confirmation would not change the ideology of the makeup of the court. So if they were moderate conservative replacing a moderate conservative, or a moderate liberal replacing a moderate liberal. In those 12 cases, which fit those three characteristics, up until 2000, actually up until 2008, the average number of negative votes was 3 in the Senate out of 100 cast. Okay? In the Kagan and Sotomayor confirmations, which fit those three characteristics, there were 37 negative votes in those two cases. So what that demonstrates has been this profound politicization of that process. In the past, members of the other party deferred to the president as long as those three conditions were satisfied. Wasn't going to change the court, relatively ideologically moderate, and obviously qualified. Now that's no longer true. And the reasons that's no longer true are partly it's because of the increasing perception of the political role the court plays. Mostly it's the result of interest groups and the internet. So it used to be the case that Supreme Court nominations were largely invisible to the public. The public didn't care very much who was nominated to the Supreme Court. The first hearings to be televised, and it was on NPR, was Sandra Day O'Connor in 1986. Now, of course, because of the change in news and the internet and cable, the whole confirmation process from beginning to end is a media circus. And the consequence of that is that it's become much more visible in the public arena. And so what does that mean? What that means is that interest groups motivate their members to lobby their senators to vote for or against a candidate based upon their perception of their political views. And so as recently as 15 years ago, there were only 9 interest groups who submitted materials into the Senate in confirmation proceedings. That was the highest ever, and it was 9. In the Kagan and Sotomayor, there were over 100 interest groups. And senators now are on national television when they ask questions, and their votes are made very visible to the groups, whether it be the NRA or National Organization for Women or whatever. And so they're playing politics, right? They can no longer afford to defer to a qualified nominee, even if it's of the other party, because now they're being held accountable by their constituents. And so because of that, their votes have become much more contentious, much more polarized. And that's a major problem in the process as well.
I'm tempted to dissent on a couple of points. I'm not sure Mayor.
Maybe you're not an expert, so isn't it?
I'm not
Well, you're
sure
free to
Mayor
disagree.
Nagel's policies, anti-prejudice policies are going to just fit under time, place, manner stuff. But I think actually I would win a dissent on whether my introduction was extreme.
Let me say, on the AC, you can't dissent on it. What do you know about the First Amendment? You can say it's bad, we should not do that. That might be true. That doesn't mean as a constitutional matter that's the case. The issue was, is the ACLU and the National Organs right in deciding they're not going to win the case?
I thought I'd only win the second point of dissent with this jury. I don't think my introduction was extravagant, but also, while we got you up there, glad to argue this point on other terms. Can you, feel free to plead the fifth, or would you speculate a bit, fantasize a bit, share your thoughts on what kind of constitutional amendment you would ever like to see happen?
About what? Anything?
Anything.
If I could have one constitutional amendment right now, which I think will never happen, but fantasize is the right word, it would be one that overturns Citizens United and the Buckley v. Vallejo, which was the 1974 case. That is, I would have an amendment that said something like, in order to ensure the fairness and balance of the electoral process, Congress in the states may enact legislation limiting expenditures by individuals and corporations in the political process. I think that's really central to the future of our democracy. And I fear, first of all, I don't believe there's any chance of that being adopted because you have to get 3/4 of both houses of Congress. Good luck, right? And the only way that could happen, by the way, is if people who do not like Citizens United actually make this a fundamental issue in the political system and tell their representatives, whether they're Republicans or Democrats, I'm not going to vote for you, right? They need to take this issue with the same degree of strength that anti-abortion people take the pro-life position. You know, I'm not going to vote for you if you do not oppose abortion, period. And I think if people are serious about Citizens United, that's the only way it'll get enacted. If basically members of Congress understand that their constituents will vote them out of office if they don't do what they want on this issue. I'm very skeptical that could happen, but that's the only way it'll happen. But that would be the one, if I could magically put in the Constitution, I would put it in. I think it really threatens the very future of our democracy. Thank you all very much for coming.